Okay, we back in session and calls number 330126. Mr. Hammond, you've had an opportunity to review the defendant's motion.
Yes, Your Honor, I have.
Okay. Mr. Lawrence, you'd like to go forward on your motion?
Yes, Your Honor. Basically, I prepared this affidavit and a second one that goes even further in wanting to drop the case. It's not yet before the court. I prepared these and sent them to her, and she filled them in and signed them. I didn't talk to her very much except to say that tell me anything you don't want in there or that you want to add. That was basically what I said to her on the phone. I didn't put any words in her mouth. She participated in adding some language herself after she had looked at them. She does not want to go forward in this case any further, which if you understand everything about it, it's very understandable. They've both known each other a long time. I'll just put it that way and not go further than that unless somebody testifies. But I'll just briefly say in the I think the police affidavit supported that they had been engaged before for a pretty good while.
Okay. Mr. Ham?
Yes, Your Honor, the state would oppose this motion, not with complete prejudice, but opposed at this time. The office has a policy of only accepting affidavits of non-prosecution that are of its own form and that are completed in the office after taking the options class at the DA's office. And even then, from time to time, the state will decide to proceed. So in the first instance, before the state would consider dismissing this case on the basis of an affidavit of non-prosecution, it needs to be one that was filled out and completed in our office on our form after taking the options class.
Okay. Now, okay, so Mr.
I
have something else?
believe I will add this second affidavit that has an additional paragraph that she contributed to greatly, the wording of as Exhibit A. I asked for exhibit stickers a minute ago. I can't find an exhibit sticker.
Exhibit stickers over there by the court reporters. Is that the state?
Okay.
I mean, okay, defense.
Thank you. Yes, perfect. This will be a defendant's Exhibit A. And it has another paragraph here at the bottom. Would you like for me to pass it to counsel before he hands it to you?
If you want to, yeah, you need to review it.
Yes. You will see she's very adamant about dropping the prosecution.
Your Honor, I think the state would argue too that the language and the information here tracks the statutory language, and that those are matters for, as far as these evidentiary matters, are matters for trial itself rather than the four corners of the information which this is seeking to quash.
Okay.
And the bottom paragraph is the one that was added on this one that she wanted added. Most of that she wanted added.
Okay. You over through?
I'd like to tender that as Exhibit A whenever he
Any-
finishes.
Oh.
No objection, Your Honor.
Okay.
We tender that as a defendant's Exhibit A.
Okay. That exhibit A will be admitted into evidence. Any do we have anything else? Any other evidence that you'd like to go forward on?
No, Your Honor, I would recommend you read that last paragraph on the Exhibit A.
Okay. Okay. Mr. Ham?
Yes, Your Honor. Mr. Boyd has just pointed out a little case law to me. It states regarding motions to quash or dismiss informations or indictments such as this, motions to dismiss or quash can't be used to attack the sufficiency of the evidence to support an information or indictment. And that these are really matters for trial.
Okay, now, pursuant to Article 32.02 of the Texas Code of Criminal Procedure, the trial court does not have the authority to dismiss a case unless the prosecutor acts for dismissal, except in a few circumstances. And that is stated in State versus Johnson, 821 Southwest 2nd, 609, as Texas Criminal Court of Appeals, 1991. State versus McNutt, 405 Southwest 3rd, 156, Texas Appellate Court of Houston, the First District, 2013. And
Is that 156?
156, yes. 405 Southwest 3rd, 156. And the trial court has authority to dismiss charging instruments with prejudice: 1, for defect in form or substance, or 2, for denial of constitutional right to speedy trial, 3, under Article 32.01, the right to a speedy indictment, but only for arrest before May 26 of 1997, or 4, if prosecutorial misconduct prejudicially violates the defendant's right to counsel and excluding evidence will not cure the prejudice. And that's pursuant to Johnson at 821 Southwest 2nd at 612, State versus Fry, 897 Southwest 2nd, 324, and 330 Texas Criminal Court of Appeals. But this list is not exhaustive. In the state of Texas versus Terrazas, which is Terrazas, 962 Southwest 2nd, 38, Texas Court of Criminal Appeals, 1998. Now, Mr. Lawrence, we have this hearing without the presence of a court reporter. Are you waiving a record in this case?
So I would, if we set it for trial, then I would require a record at the trial.
So I'm saying for the
Well,
court.
actually, because of the fact of the ruling you're going to make, I would need a record for the ruling I
Okay.
think you're about to make.
Okay, well, let's do this here. The court is not going to make a ruling at this time. Hold on a minute, we'll be in recess. Okay, so prior to the court making a ruling, the parties have come to an agreement, is that correct? Is that correct, Mr. Ham?
An agreement of sorts, yes, Your Honor.
Okay, okay, and so what we're gonna do, the court is not going to make a ruling now, but if need be, later on, then the court will reconvene for a hearing with a court reporter, and then we'll go forward. Is that fine with you, Mr. Lawrence?
Yes, Your Honor. Yes, Your Honor.
Mr. Ham?
Yes, Your Honor.
Okay, so how much time do we need?
I would say a month to, I don't know how often the classes are held, need to contact, the victim's assistants.
Right.
And-
It would
and
need to
come in.
be, I would think, to make sure that we miss the holiday season. that it
Right.
would- It would be at least the end of January, 1st of February.
That makes sense, Your
Okay,
Honor.
give us 60 days will be
That makes
fine?
sense.
Right.
60 days is February 11th.
Forgot about the
Will
holiday.
that be fine? February 11th?
February 11th.
Okay, so we're gonna reset for February 11th,
What time, Your Honor?
9 o'clock,
9 o'clock.
yes.
Is it gonna be a hearing again or what?
Well, put it, you can just set it for here. But if it's resolved, then my understanding, we would not need it here.
That's correct, Your Honor.
Okay.
We hope we can resolve it.
Okay,
Good, good.
all right. So, Mr. Lawrence, you can stand over there and get your reset. And, Mr. Lawrence, once you, get your reset, Mr. Davis, you get your reset from your attorney, Mr. Lawrence, you'll be free to go and you have a blessed day. And Mr. Lawrence, you, be free to go as well and you have a blessed day.
Thank you very much, Your Honor.
Okay,
Thank you, Judge.
okay. Okay, the court's back in session in both dockets. Motion to revoke probation docket, which was scheduled for 9 a.m. on today's date of December 3rd of 2021 is complete. And the announcement docket, which was scheduled at 9 a.m. on today's date of December 3rd of 2021 is also complete. And we don't have any bond forfeitures on either one of the cases. So at this time, both docs have been complete and calls in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.